Welcome to Secure Money Mindset, the ultimate podcast for financial planning tips and strategies. Our episodes are designed to be concise and to the point, lasting no more than 30 minutes. Each episode features seasoned advisors from Secure Planning Group or an outside financial specialist discussing crucial issues and providing actions to consider when addressing your top financial concerns. We value honesty and transparency, meaning we present both the good and the bad news in a clear and concise manner. Our goal is to provide you with reliable insights and practical guidance. Be sure to hit the follow button to stay up to date with our latest episodes. For more information, please visit our website at securepg.net. Let's dive into this week's episode of Secure Money Mindset.
Mike Lenge with Secure Planning Group here. Thanks again for joining us. Here with me today is Lauren Kays, an estate attorney with Bogar and Hipp Law. We're here today to talk to you about estate planning for real estate investors. So we're going to go over some things that really could apply to a lot of folks, but in the frame specifically today to talk about real estate investors, because there are some different kind of considerations that those types of folks should be thinking about that may not apply to the everyday average person who doesn't have a lot of assets or own real estate. So Lauren, thanks again for joining us today.
My pleasure to be here.
If you could maybe just review for us kind of the basics of, like, again, as I mentioned, the considerations that a real estate investor should have that maybe the average person doesn't.
Sure. So it all starts with, how do you own this piece of real estate? And perhaps it's via an LLC, and maybe you have other owners or members of that LLC. You've worked together to invest perhaps a certain percentage, and that's reflected in the ownership interests you have in this LLC. So what do your ownership interests mean? Where are you percentage-wise in the big pile together? And what are any limitations on your ownership interest that may have been written into the LLC operating agreement? Or if, say, we're in the context of a corporation, the bylaws, or a partnership agreement. Understanding the implication of your ownership interest here and now is the starting point. The next question is, what limitations do you have on your ability to sell or transfer your ownership interests? And how does that align with your long-term goals, your long-term estate planning goals? So perhaps we start with either buffering or undoing some of those limitations on transfers of ownership interests by way of an amendment to an operating agreement, or maybe we just draft an operating agreement that wasn't put into place in the first instance, which we've seen. Then on the back end, making that work with your estate plan, work with your last will and testament. It's also important to understand when you take title to real estate, say it's owned among one or more LLCs, what does that mean for you as an owner of perhaps one of them? So that's important to understand, and ask all those questions of your estate planning attorney, your real estate attorney, and your business partners. Have a frank conversation with them about your goals for the ownership interests as they work together in that entity and long term.
I think everything you touched on is really important. What it brings to mind for me is everybody's at different stages, right? When they come to you as the professional. They either have their ducks in a row or they don't know where to start. Sure. And anywhere in between. So I think the one thing you brought up first was the operating agreement, right? Does your LLC have an operating agreement, right? So as a professional, we want to assume you have some of these basic things already in place, but it's not fair to make assumptions, right? So like we want to ask first, hey, do you have it? If you have it, when we review it, is it in line with your own personal estate plan, which is what you're alluding to? And does that need to be insulated or protected because it has somewhat differing interests than the LLC's plan, so to speak, or how the operating agreement that owns the real estate aligns with your own personal plan, right?
Absolutely.
So it's working with you to bridge the gap as the estate attorney, but also looping in the other professionals, like you mentioned, the real estate attorney, your financial advisor, your CPA.
Absolutely.
To make sure that we're not working against one another. And you're aligned with your own personal estate plan, not just the interest of that LLC or the operating agreement. So education is the biggest piece, like across all these types of videos, right? It's, do you know what you should be asking? And are you asking the right people?
Sure. And knowing what you can transfer, what are the limitations that have been built into your organizational docs. Also, understanding and creating a plan for once you know what you can transfer by way of memorializing it in your will, or perhaps adding an owner to an LLC, so they're sharing in the pie during your lifetime. What are the limitations that you want to put in place on those transfers? Do you want to gift or allow, say, a set of children to inherit more than just ownership? Will that also include the ability to operate and manage that portfolio of assets? All things to consider. You're definitely coming to the table with a lot of questions that we can help you navigate based on understanding what is currently in place now and what we can possibly do to modify, shift, change to achieve your long-term goals.
Yeah, and I think one of the pieces addressed right there is really important. When you come across, I like to call it operator, for lack of a better term now, the operators of these real estate ventures, right?
Right.
Typically, you have the business mind, and then you have kind of the rubber meets the road mind, right? Where it's like, hey, you have the guy who's working with the general contractors, making sure the work's getting done right, and then you have the guy who's keeping the books. Again, that's not all cases. But in that simple example, having a succession plan or some form of plan in place to know what happens if one of those operating parties is no longer there is really important, and who is making the decisions after the fact, right? Whether that's an exit that is agreed upon, or that's an exit that is out of your control due to the passing or incapacity of one of the partners.
Sure.
And in the example I gave, you can see how those plans could be imbalanced depending on which party isn't there, right? To where if it's the business mind, obviously there needs to be something in place to protect the person who never had to think about any of those things, and vice versa. If the guy who's in charge of all the physical labor is no longer there, what's there to protect the person who never had to do any of that? And then in the example of family, I always think of like the family members who are involved and the family members who aren't.
Correct.
And if they share equal weightings, how do you have it verbalized, or how do you have it explained in the agreements to make sure that it's in line with your estate plan?
Absolutely.
And these are all the nuances where it's like, it's not going to be an answer that we can give to you when you come to us, right? We're going to need to know a lot about your personal situation before we ever make any type of recommendation.
Sure.
So it really just goes back to like working with a trusted contact like Lauren. If you're working with Secure Planning Group as a client of ours, we're introducing you to Lauren because we know she's aligned with the way that we view things. She does a great job. But we know that if we present some pushback to something she might be recommending to one of our clients, we're not doing it for any other reason other than this is what we think fits in the financial plan. And this is why we think it needs to be set up this way to align with this interest. So we're focusing on real estate investors, right? But these kind of nuances apply to everybody, right? You don't have to own a lot of assets for these same examples to come into play. When it comes to like setting up the succession plan itself through an estate plan, can you maybe just allude to the ways you can put this type of language into either agreements or trusts?
Sure. So it's important that your plan is memorialized in writing. And as a real estate investor, you probably know that the golden rule of real estate is it's not enforceable if it's not in writing. And there is no one size fits all for each client. We really need to know the nuances of how and what you own, any built-in limitations we need to adhere to or perhaps seek to modify in reaching your long-term goals. The key is that you have not only good organizational documents for your LLC, you understand the implications of how you own real estate, how it's titled, and then in your estate planning documents, not only your last will and testament, or perhaps a trust is not usually, but can be a very good fit for the owner of a large real estate investment portfolio to preserve generational wealth, to preserve that portfolio of assets for their heirs, but also powers of attorney that designate who manages things during your lifetime if you have a health hiccup or setback. That's really important as well. And you want to make sure the individuals you name across the board are able to work well and carry out your business operations as you want them to be carried out, to keep the momentum going, to be able to work with business partners and create a system of checks and balances, so to speak. You want to make sure that, you're not relinquishing control altogether to a business partner in the hopes that they're going to keep your family's best interest in mind. You can kind of divide and conquer the roles, so to speak, in your own personal estate planning documents to hopefully achieve the best end result in terms of asset protection and preservation.
Yeah, the most common example that we were joking about prior to the video was like nobody wants to do business with their business partner's spouse right after their passing. And it's like the example that always gets tossed around in passing, right? And
you don't even necessarily have to pass away. Sorry to interrupt.
No, that was going to be my segue, right?
There's so many health events that could happen that takes them out of the picture even during their lifetime. Yeah, go ahead. Sorry.
No, you're good. I was going to say you brought my attention to an example in a previous recording. It could be an example where you are just unable to make decisions, right? And it doesn't have to be one of these dark examples. It could just be, hey, I'm stuck on international travel for an extended period of time, right? And you gave the example of COVID, where if you were stuck in Europe and you run an operation where it requires you to physically be there, signing off on documents and making decisions, that's an example where the POA needs to be in place. So legally, somebody could be making decisions to keep the operations moving.
More frequently, or in more recent history, we've seen the example of natural disasters preventing individuals from being able to go or come home. And that impacts management decisions that need to be carried out. There's so much you can do remotely, of course, but there's always exceptions to that. And there needs to be a plan in place if you can't be physically present.
Yeah. Yeah. And then even something as simple as like in those examples where if you're the more hands-on operations guy and you have some type of surgery where you're off your feet or you can't use your body or whatever for months at a time, do you want to take 6 months out of operating whatever you have going? Obviously could burden you. So all examples of people always use death or incapacity as the example. There could be other circumstances.
Sure. Maybe your loved ones are going through something and that takes you out of the game temporarily. So you need to be able to plan for all possible scenarios where you're not able to be there to make those immediate decisions that would be in the best interest of your investment portfolio, your companies, to keep those decisions and management going.
Yeah. And ultimately, it's your legacy. It's what you've built.
Absolutely.
Right. And so protecting it is as important, if not more important, than what it takes to build it. Two of the tools that we kind of brainstormed ahead of time as well were trusts and then gifting. So like if you could maybe just speak to, there's a moving target when it comes to regulation and what your lifetime exemption will be. And there's a lot of speculation of as to whether or not the sunsetting of those limitations will stay in place. But as a real estate investor, as opposed to just an average person who might have a lot of assets, can you maybe just speak to like when those limits come into play, what they are today and where they might go?
Sure. So at present, there are pretty generous exemptions for estate, gift, and generation skipping transfer tax implications. So for an individual, we're presently through the end of 2025, unless Congress acts to extend these exemption limits, we are at 13.61 for an individual, 13.61 million for an individual, and 27.2 million for a couple. However, unless these limits are extended by congressional action, they're set to roll back to the 2017 limit of 7 million per person, which introduces a potentially huge group of individuals who may not be at that 7 million mark yet, but could be in the next couple years or year, but also would impact the highest earners in our society. So having a conversation with your trusted financial planner, your CPA, and your estate planning attorney about, first of all, determining what is your scope of vulnerability with respect to the rollback. Will you definitely be in that category of impacted individuals? And if so, what actions do you need to take now in terms of, should I start doing some lifetime gifting? Could I attempt to shield something in trust now? What would be the best course of action? And not to panic, but the first step would just be understanding where you fall in this framework. That's step one. And then making a plan in the event the rollback happens. What is in your best interest? So again, it's not going to be the best idea for everyone to start doing a ton of lifetime gifting or attempting to shield things in trust, but it could be. And it's important to understand what are your options and what's the best fit for your set of circumstances.
Yeah, and keeping things simple, like I feel like it's really hard for somebody who's in their 30s and 40s if they're worth $3 to $5 million today because they've worked their butt off to get there, right?
It's impressive.
Yeah, it is. It's very impressive. It's hard for them to think that 13.2 million or 13.6 million is going to apply to them.
Sure.
But if you stay on track with what your pace is and you're compounding your wealth over time, you can quickly get to those limits.
Sure.
So having a plan in place that is aligned with what your goals and objectives are for the future at current time, but knowing that it's a moving target over time, knowing that these regulations will change and that's out of your control, revisiting this plan is
Absolutely.
as important as having it in place. So in that example, say if you're the 30 to 40-year-old investor, you have something in place then. Fast forward to when you're 55. If you're that 55-year-old investor and you're looking back and you've accumulated all this wealth, if the last time you revisited this plan was when you were in your 40s, it needs to be revisited. And hopefully your asset values have grown. That's the goal. Whether or not you feel like you said, you're exposed to those limits today, we might, as your planner, say, if you just continue on the path you're on, those limits will apply to you by year X.
Right.
So we have until year X to address those things ahead of time, right? And then if we know when those rules sunset, like as they're set today, it would be the end of the calendar year. We've been speaking with our clients where they are exposed over the past 2 or 3 calendar years, preparing them for the sunsetting of these limitations. So we educated them, allowed them to decide whether or not it's important enough to them to make those gifting decisions or maximize their lifetime exemption. So these are all examples. It's like you can Google it to see what the answer is. You can Google to see generically what the facts are, but it does not give you the advice that is nuanced to your specific
Absolutely.
situation and goals.
Google's not going to deliver the most effective estate plan for you.
No, and it's also gonna just create 3 to 5 more questions for you to ask and get confused.
There you go.
But I think we really kind of hit the highlights. Was there anything more geared towards a real estate investor that you thought needed to be mentioned about estate planning in general?
I think we hit the important ones, Mike.
Perfect. Well, I appreciate you kind of talking through all this stuff with us. And most importantly, if you have any questions about anything we spoke about, Lauren is a great resource. And we're happy to answer any questions you have. So thanks again for tuning in, and we hope to see you on the next time.
Thank you.